20-21516-FH. People of the State of Michigan versus Donald Raymond Laurent Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for Prosecutor of Record Isaac Sneed.
Samara Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting.
I can see you.
Almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter in order for us to move to trial. And he was very upset. I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction, I
can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, State of Michigan. This is the circuit court for the Lenawee County, State of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not. I know I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction. It's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules, that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing, that you said that you have jurisdiction over this case, but not the said person. And that's all in the motions that I sent over to the clerk's office. I also have them all notarized. I also have copies of everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor,
and personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform you yesterday.
He's not addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os, which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about the plea agreement that would allow him to be released today. So he is correct in that I did inform him of that, but it's not because of a habitual offender notice. And he asked me about that yesterday, and I reiterated again yesterday that that is not why. That was not why he's facing that amount of time. It was simply me telling worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
okay, so whenever you get done, I'd like to address the issue too, please.
All right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go,
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes, it would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an added count for possession of meth in a park, which is a 2-year offense. And we were offering credit for time served, which is approximately 10 months. And we have no objection to a PR bond at the time the plea is taken.
Ms. McClure, could I just add that Mr. Sneed did inform me that you had authority to do fines and cost only on this as well? Would that be accurate?
I think that would be part of the credit for time served.
Thank you.
So the prosecution has made an offer to resolve the case if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served and or fines and costs and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there and coerced me into trying to keep her on my case.
All right. So, Mr. Lester, that wasn't really responsive to the question that was asked. The question you're being asked.
I don't know
right
nothing
now,
about that. I told her what it was then. And
Mr. Lester,
you keep trying to cut me off.
well, that's because you won't let me create the record and do my job. So I'm trying to
do my job. You're not the one sitting in jail, sir.
All right. So, Miss
Your Honor, would you
All right,
please
so
mute my client? I don't want him to.
record should reflect that. The record should reflect that Mr. Lester had. I'm sorry. So, Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor. And I wasn't bothering anybody.
A simple no is fine. That's all I needed. All I needed was no.
Quit talking to me like I'm a kid.
The answer is no, so we will proceed to trial next week. I don't think there's anything else we need to address this morning. So Mr. Lester,
I need a bond.
that you are done with court.
See what I'm saying?